What's up, everybody? We are here for day 4 of the Sarah Boone trial. The defense is all but done with their case. It was full of expert testimony. We learned everything there is to know about the battered spouse syndrome and how it may or may not apply to Sarah Boone, at least as far as the defense experts think and opine today. We're going to dig into that. We're going to answer all your questions. We're going to talk about the other evidence the defense presented. Are they moving the needle for you? Are they moving the needle for this jury? Let's talk about it. Here we go. So the first couple witnesses for the defense were pretty quick. And they flew through them for the most part because they were getting up on the stand to testify to just basically one or two facts to corroborate some of the other Boone testimony or other arguments that the defense has made. And some of those witnesses were Officer Ramirez-Delgado, who responded to a DV call. Boone had swelling and bruising on her face. Torres had some abrasions and bruising on him. They ended up arresting Boone, and Boone asked why she's in trouble. Is it because she was fighting back? And I'm not really sure why they even brought this person. I would not have brought this officer on, by the way, because they have the next one. They brought this officer on. Maybe they brought her on because they thought the state would, but the prosecutor gets up and is like, so you talked to everybody, you took in all the information, and then you made your decisions based on that, basically inferring you talked to everybody and Sarah Boone's the one you ended up arresting. Then they bring up another officer, another DV. Boone had redness on the neck. Torres had redness on the eye. Torres is placed under arrest. Now the state asks for this one. He didn't say anything, and there was body-worn camera. So when we talk later about the state is planning to play hours potentially of body-worn camera from law enforcement officers in their rebuttal, remember this witness because I think theirs is probably going to be at least some of it. Then they call Officer Koepsell back. And if you remember back when I think it was Mr. Marino was testifying and the defense attorney was like, you sure you said she was going to teach him a lesson? Are you sure that she said that things got out of hand? And he's like, yeah, I said that. He's like, are you sure you said it to Officer Koepsell? Oh yeah, I'm sure. And I said, it seemed like he was going to impeach him, but he never impeached him. If it was me, I would have probably taken a step further with Marino to been like, so if I asked Detective Koepsell and she says she doesn't remember that, is she lying? I would have asked him something like that to really set it up. So the jury, not just me, but the jury noticed that's what he's setting him up to do because that's exactly what he did. Koepsell took the stand. Koepsell said Marino never said that. And it worked out perfectly because she had to refresh her recollection. And so they used her report and she said, yeah, no, it's not in my report that he said that Sarah Boone was going to teach George a lesson or that things got out of hand. And those were the really important parts. And that impeachment was completed. Then we get to Dr. Brannon, a psychologist. They go through education experience, 50-50, whether he testifies for state or defense. They try to tender him as an expert. They object. They go to sidebar, so I'm not exactly sure it was argued. It was sustained, but he was absolutely asked, at the very least, hybrid questions. He was able to get into hypotheticals. He was able to answer questions about battered spouse syndrome in a way only an expert would, with expertise to help educate the jury in ways that laymen would not understand. So from my perspective, even though that objection was sustained, he was absolutely treated as somewhat of an expert on battered spouse syndrome, not specifically testifying about Sarah Boone, although everybody gave him hypotheticals that could absolutely be applied to Sarah Boone. So technically he didn't treat or meet with or talk to Sarah Boone, I guess. And we have the witness later that's going to actually get into that. But he does give us a background on battered spouse. He explains to us some of the dynamics, and we're going to listen to him explain it. I personally thought he was a good witness. I thought he had good explanations. I thought he had good analogies. I thought he was very honest. And that's one of the reasons why I thought the cross of this witness was amazing by Mr. J. And we'll get into that. But his explanation here is kind of the jury's first expert explanation of battered spouse syndrome, which they've heard so much about already in the first 3 or 4 days of this trial.
violence when they've been the victim of violence. Now we know, of course, in other kinds of relationships, men can be a victim of it as well, as whether it's a heterosexual or homosexual relationship, that both men and women can be victims. But we still know the majority of those individuals that are diagnosed with that condition or given that condition, classified with that condition, are women. We do know that it's a reaction, a strategy that's developed by the person who's being abused to someone who's abusing them in an intimate partner situation. And essentially what they're doing is they've made a determination that they can't effectively escape from the abuse. They can't just flee for some reason. They feel in danger or they've been threatened.
I'm going to slow it down a little bit because expert testimony sometimes can be harder to pick up on when it's sped up. So I'll slow it down a little bit so we can all keep up.
If they leave, that something bad will happen to them. So it's a cognitive or thinking strategy on the part of the person being abused that I have to develop some coping skills or ways of protecting myself or maybe even loved ones as well from some form of imminent violence or danger or lethality. Something bad will happen to me if I don't develop a way of handling this abuse, this constant abuse that's coming towards me. So the battered wife syndrome is really a way of thinking. It's a psychological change that happens with a victim in terms of the way they cope and strategize to stay safe for themselves and other loved ones as well, oftentimes.
I'm going to ask a really silly question, if I may, Doctor. I don't know if you've noticed a bruise across the bridge of my nose this morning.
I did see that when I came in. Yes, sir.
Okay.
Started out as a really rough analogy, and they're not going to let him ask, questions about himself. So that's why he turns it into a hypothetical. That's what the objection was about, in case you're wondering.
This weekend, hypothetically, if an individual was digging around in the garbage, the lid fell down and cut his nose, the bridge of his nose wide open, would you, as a forensic psychologist, anticipate, or a psychologist in general, anticipate that there might be a physical or a psychological reaction in response to that degree of trauma?
So I don't know if it would be trauma or not. It could be, depending on the degree of the injury and the pain and things like that. But certainly you'd view that garbage can differently as you approached it. So it changes your psychology or the way that you look at that particular situation or that particular object. So by viewing it differently, you may engage in different behaviors. You may approach it differently. You may have somebody else approach it. You may approach it with both hands up. So it changes your behavior and your thinking about that garbage can.
Does that also apply?
I think that's a good explanation. I think that's a good analogy. It's like, and it's true. Have you ever done something like that? Drop something on yourself? Then the next couple times you go to put a book high up on a bookshelf, you might do it a little more trepidatiously, right? I get that. That helps me understand. I love when experts can help lay people like myself, right? I'm a lay person when it comes to psychology, and he can help me understand what he's trying to explain. I appreciate that.
To interpersonal relationships?
So it certainly can. No two people always react the same way to every situation. Trauma, one person's trauma is not a trauma to another person. But for people who do develop battered spouse syndrome, they do begin to change the way they view the person who's abusing them and what they have to do in order to maintain either their life or their safety, their physical safety in terms of their behavior and interactions with that person.
Now, is there a specific set of criteria that a forensic psychologist would necessarily rely upon in attempting to make a diagnosis or an assessment of battered women syndrome?
Yes, sir.
And what are those criteria?
Well, you'd want to see one if some type of abuse has occurred. That abuse can be physical, it can be sexual, it can be emotional, or it can just be the threat of abuse or bad things that's going to happen to you. So there has to be something bad that's happened or that's threatened to be happening over a period of time. So abuse has to be present in order for this to be underway. Without abuse, there's no battered wife syndrome. But that's not enough.
He does. He's an older gentleman. I mean, I don't know how old he is, but obviously he's been around a long time to where he keeps saying battered wife syndrome, which I find interesting, right? I don't know if he does that on purpose because he's representing or he's working for the defense who is claiming to be a battered woman, right? Not just a battered spouse or battered person, but battered woman, battered wife. He talks about how women are more likely and they're more often diagnosed with something like this. And from my perspective, that is important in a case like this where the state is clearly trying to make it seem like, and their argument and their angle is George was actually the battered spouse. George was actually the battered person. So I don't know if he's doing that on purpose or if it just because, sometimes when you learn something, the same things happen to me with law change or whatever, the first way I learned to say it or the first way I would say it is still what's stuck in my head. And it might be that, but I definitely noticed it throughout his testimony.
There also has to be what's called coercive control. Coercive control is really keeping the person's social interactions, overseen on a regular basis, controlling money, controlling preferences, even TV preferences, sometimes social media, looking at social media that the person is accessing or looking at, who they're talking to on Facebook, who they're texting. So it's a combination of abuse and coercive control that results in a person feeling victimized, but that's still not enough. That person then has to feel like they can't escape from that. They've either been told, if you leave me, you're going to die, or a family member is going to be harmed. Your
And we know those are some of the threats she was or some of the accusations she was making against George when she was on the stand.
children, your mother, whatever it might be. And as a result of that, they develop strategies to cope with that, acquiescing, pleasing, doing anything they're asked to do, demeaning themselves, allowing themselves to be controlled. All of the things that would fend off, if you will, some abuse or attack or threat to them or someone who surrounds them. So those would be the components that you would need to have. And that dance continues to go on usually repeatedly throughout the course of that relationship.
So a good explanation, I thought, a good kind of opening to us to start getting into it. Thank you, Rebecca, for gifting 10 memberships. And thank you, Azam, for gifting 5 memberships. A bunch of new Lawyer You Know members coming in tonight. So once he gave kind of that overview and explanation, I thought he gave way too many analogies that just did not apply to Sarah Boone. Whether it was Stockholm Syndrome, whether it was somebody feeling trapped or controlled by money, whether it was somebody feeling trapped and controlled by ownership over the house or the car or whatever it may be, it's like none of those really apply to Sarah Boone. And frankly, it made me think of George more than it made me think of Sarah with some of the analogies he was given. He also started talking about physical manifestations and perceptions and how all that works together with the battered spouse syndrome. So let's listen to his explanation here, kind of at the end of his direct, explaining how all this works and fits together.
Syndrome, they oftentimes adapt, defend, and take on in an acquiescent way that this is okay and I'm part of this situation as opposed to the situation.
Will this syndrome exhibit itself in physical attributes?
It can, at times, even physical illness at times.
Inability to sleep, inability to keep food down, and those type of things.
Sure. Yes, sir.
Would that individual potentially experience hypervigilance?
Well, that's a large part of it. Any trauma-based disorder is hypervigilance. What changes when you've been traumatized, any kind of trauma, not just abuse, but what changes is your perception of danger. So whether it's the lid of the garbage can hitting on your nose, or whether it's someone being abusive towards you, those situations change your perception of danger. So you no longer see that object or that person in the same way. You have a foreboding sense of danger could occur. So other people may not perceive it with that person. He's so nice at work, or he's nice at these other settings, or he's so great on the softball field, but at home he's different. So that person who's being abused, their perception changes.
Does that include denial?
It could include denial, and oftentimes that's part of the explanation. The defensiveness of that person is the denial of how bad things are that are going on.
Thanks, Doctor.
And that was his testimony. That was the gist, right? Just hitting the highlights here as we always do. Max Sauce, I'm glad you're back. Glad you're back. So I'm going to answer some questions here before we get to the state's cross. Peter, did I hear you say earlier today that the state cannot call Sarah during their rebuttal argument? So this is a very interesting question. Practically speaking, I feel confident in my no, that it's not going to happen. I've never seen it happen. I've never heard of it happening. I've never asked for it to happen. I asked my dad as well. He said, absolutely not. Never heard of it happening. Never did it. Never saw it happen. But when doing some research, I feel like there is an argument to be made where it is potentially possible that the state would be allowed to. Now, first off, any rebuttal witness can only be called if they're explaining, rebutting, contradicting something that came out in the defendant's case. So first off, that would kind of be hard. How did they do it? They were already able to cross-examine her. You really can't save that for rebuttal. But the law in Florida, I think it's 3.250. I put it up on Twitter today. It talks about how when the accused becomes a witness and they waive their Fifth Amendment right, they are basically supposed to be treated as any other witness. They are subject to examination as other witnesses. And most of the time we think of that as they're going to submit to cross-examination. But other witnesses could potentially be recalled on rebuttal. So I do think there might be an argument that it is possible. I just don't practically think it's going to happen here. I don't practically think it's something that happens very often. I think there will be a very big fight after an objection if they try to do something like this. But I think it is theoretically possible. So, my answers have kind of bounced around on this one because this is one that I have never seen happen in Florida, but I guess it's technically possible. Reggie, new member, Peter, your thoughts, please. If being under the influence isn't a defense, what about the girl who smoked weed and stabbed her boyfriend and got off? I love hearing your perspective. So, Reggie, I would need more than that. I don't know specifically, but most states, and I know Florida is like this, but most states, voluntary intoxication is not a defense. You cannot get off and be not guilty if you choose to ingest drugs or alcohol to the level that they make you intoxicated. That is not a way to get off. And I'm speaking for Florida with that. So I need to know more about that case. Chris K, John or Kelsey, Peter, has anyone seen Netwoman? I have not. I have not seen or heard from her in a little while. But sometimes, people that are in the channel all the time, sometimes they lurk, sometimes they come and hang out, sometimes they're more loud with it, which is awesome. And everybody just kind of does their own thing. I hope she's okay. If anybody hears from her and there's issues, please let me know if there's anything I can do. Summer Golden, hey, Peter, why is the state not objecting more? I think they don't feel like they need to. Number one, I think they are objecting. If you notice, I feel like they're winning a lot of their objections. There's two ways to look at that. Either we have a biased judge that leans state's way, which, spoiler alert, most judges have a state lean, a prosecution lean. I think most people would agree with that. I've prosecuted cases, I've defended cases. I felt it on both sides. Or they're only objecting when they either think or are pretty confident they're going to win. Christy, she had the car, the phone, the home, the control, the money even from Brian. BTS not allowed in Florida as dense until 99 out of 100 or 99 2000. BTS. I'm blanking on what BTS is. Sorry, Venus Blue. I'm not understanding this question. Jax. Alcoholics injure themselves frequently. We don't know George did any of that. Neighbor said she would fall down drunk at 9 a.m. Watch previous body cams. Well, I think the state's going to play a lot of those body cams in rebuttal. So we'll see. If you haven't already heard, wait until you hear about the first date. Oh, I heard. I mean, first date from literal hell. We'll get there. We'll get there. Tay Bay. Hi, Pete. I haven't been following the trial. Can I get your opinion on how it's going? Thanks. So yeah, I think the state is doing their job. I don't think it's like a lot of home runs, but a lot of singles and doubles. But I do think the defense has presented the defense in the way they wanted to. I think it's possible that there's at least one juror that has sympathy for Sarah Boone. There's at least one juror that thinks she was afraid for her life. I'm not saying one specific juror, by the way. I'm saying it's possible that they have gotten at least a juror on their side to be like, all of this horrible stuff that happened to Sarah Boone, she flipped that night when he started sticking his hand out. She thought he was and he was threatening her with his mouth. I do think it's possible, and they've presented that potential to the jury. SE Nighttime said she had all the power, house card, debit card, money, and threats of calling 911. She always wants to get her version of the event told first to police, neighbors, family members, property manager, parole officer. So yeah, there's a lot more to come with this, starting right now with cross-examination, because this is exactly the route Mr. J took. He talks about how perceptions are a big part of this. It's important to do a comprehensive evaluation. They focus on that because I do think they're going to say that the state's experts didn't, or the state's expert had everything and they went through everything. The defense experts did not. And I will tell you that is incredibly important. I talked to a juror last month who was actually married to one of my employees, and he was on a car accident trial. And he said the biggest difference between the two experts is one expert had all the records, all the background, all the police reports, everything. The other expert only had one little portion. So obviously the person that had them all was more credible. And while that doesn't always ring true, because not all treating physicians need to have all of the records or the police reports or whatever, but many times if you make that argument to a jury, they're going to think that the expert that has everything is the more credible expert. We'll see. It seems like the state's setting that up. But let's listen to some of the cross-examination here by Mr. J, which I thought was really well done.
Do you agree that obviously the person who is accused of committing a crime, there are credibility issues that you do need to care for when relying upon that person's history provided about the events leading to that and the past events describing the relationship with the intimate partner?
Yes, sir. In every forensic evaluation, that's the case.
Is this particularly important if there's a comorbidity with an alcohol abuse disorder?
Yes.
And can you tell the jury what alcohol abuse disorder means in the DSM-5 TR?
Sure. It's the biggest part of it is it's not just the use of alcohol, it's impairment that happens as a result. So it's the excessive use of alcohol, but that could mean something different, just like the excessive use of marijuana might mean. But it's the use of alcohol to the degree that it impairs or affects a person's life. And with that may come a lot of other things like deceitfulness or aggression or unreliability, sleep or somatic problems, difficulties. So, but the important thing to remember there is that it's the use of a substance that impairs or affects a person's life.
And if there is alcohol involved in the histories being given about either the event in question or any preceding events, must the evaluator take that into account when evaluating the memories and perceptions of the person giving them that history?
Yes. So introduce.
By the way, this is all hypothetically speaking, right? We're not talking about the night in question. We're not talking about anybody drinking, the big bottles of wine. We're not talking about how people that weigh 100 pounds. We're not talking about any of that. This is all hypothetical. If they forget certain things from alcohol, or they admit that they were drunk, or they admit they don't remember doing certain things at the time, the credibility of what happened that night should be called into question. He's basically asking about the psychological effects of memory loss and being intoxicated, and can we really find them credible as the most important 9 minutes? That's what I think he's getting at with a lot of these questions. That's where my mind went, at least.
That new topic about memory, we know that substances can interfere and impair memory. So as a result of that, you want to know what they were using, how close it was. If you're talking about a particular event like a crime, you'd want to know if there was substance usage, and if so, what the person's memory functioning was, and does that match up with other sources of information about what those events were.
Are you familiar with the narcissistic personality disorder?
Yes, of course.
Is that something recognized
Every time they said narcissistic personality disorder, started talking about narcissist, I cringed a little bit. I don't know why. I cringed a little bit.
in the DSM-5 TR?
Yes, sir.
And can you tell us whether or not a person who is giving a history, whether it's the patient/client or whatnot, has traits, perhaps not a diagnosis, but even just traits of the narcissistic personality disorder? Is that something the evaluator should account for in evaluating the credibility of the history given?
Yes.
And why is that?
Well, because all forms of disorders or conditions or just traits may lead to inaccurate information, either not purposely or purposely. They may be deceptive. So certain personality disorders or traits can lead to deception or inappropriate or inaccurate information. That's why you need more than one source of information. Does what this person is saying to me check out with other sources of information?
And I don't mean to quiz you on it, but can you tell us some of the criteria for the narcissistic personality disorder?
I can, yes, sir. So it is a grandiose sense of self-worth. It's the consideration of yourself over anybody else. It's kind of operating your own world. So it's an inflated sense of who you are. It's a misperception of how important you are to other people and your meaning to other people. It's a sense of specialness, that you stand out from other people in terms of special skill or skills, and that other people, if they don't recognize that, they should recognize that. So the biggest heading there is an inflated sense of self-esteem and grandiosity.
Are you familiar with an adjustment disorder diagnosis?
Yes, sir.
And is that in the DSM-5 TR?
Yes, sir. Correct.
Can you tell us about that?
Adjustment disorder is a person's reaction. It could be emotional, it can be behavioral, or it can be both, to a situation that occurs. You broke up with your boyfriend or girlfriend, so you're upset about that. And so as a result, you're tearful, you're anxious or nervous or worried about what may happen to you as a result of breaking up with them, or you behaviorally may start not going to work, or get into more arguments or fights with your children as a result. So it's a temporary reaction to a stressful situation that occurs in some individuals.
And hypothetically, if a person who is giving a history for criteria of diagnosis, let me strike that. If somebody is giving a history and that is being used to come to an evaluation conclusion of battered spouse syndrome, if that person has been diagnosed with adjustment disorder predating the traumatic relationship, is that something the evaluator should take into account?
You'd want to know any prior diagnosis because
By the way, just a hypothetical, definitely not talking about Sarah Boone, except that that's exactly what's going to come out about Sarah Boone.
it may not necessarily be exclusionary, but it could. So adjustment disorder is a temporary reaction. You're upset, a temporary, and most of them just go away on their own. Whereas something else like a traumatic stress disorder is long-term. It's something that person's stuck with for a period of time that usually doesn't just go away on its own. So yes, you'd want to know that. For that term I used before, that differential diagnosis, you'd want to know those things to compare and contrast them and hold them up against each other.
Now, hypothetically, if somebody says things like, I'm the best thing that has ever happened to you, and I'm the best you'll ever do, are those indications?
Hypothetically speaking, again, we're not talking about anybody specifically. We're definitely not talking about this case. Ashley, how can he give hypotheticals if he's not even an expert? We don't know what happened at sidebar. So I don't know if the objection was technically can't specifically talk about this case, can only talk about hypotheticals. I don't know if it was a flat out objection to an expert, but if he's not an expert, you shouldn't be able to give him hypotheticals. And he definitely shouldn't be able to go on tangents explaining what all of these technical terms mean. So he has expertise in this area. You don't actually have to tender somebody as an expert in Florida. They can testify about their expertise if they have expertise and knowledge on it, but he couldn't specifically apply it to this case. So I don't know for sure what happened at the sidebar. I would have liked to listen to it, but yeah, they're definitely asking him expert level questions. That's why I'd say at least a hybrid. Raven, this is my first super chat on Lawyer You Know. Hi, Peter. Hi, Raven. Anita, Peter, did they show the videos from her phone to the jury? Did I miss it? Well, if you did miss it, Anita, you've come to the right place because we're going to watch them. Deb, a silly game of playing with swords. Prosecutor didn't pick up silly game of hide and seek. That would have been good. That would have been good. Metzer said, Moreno told Lowen, not Chelsey, regarding the lesson. I think he said he told Koepsell, and I can't remember it 100%, but if he didn't say that he told Koepsell, he would not have been able to, the defense would not have been able to call Koepsell to impeach him on that fact if he didn't say it. So I do believe he said that in his testimony, that he told Koepsell, and that was the impeachment. Not that he didn't tell anybody, just that he didn't actually tell Koepsell, and he thought that he did. Yeah, Dre, I put it up. I'm not sure if it's appropriate for YouTube. So I when I put it up, I was like, I'm not so sure that's appropriate for YouTube, but feel free to, if you guys want to discuss it in the chat. I don't like to opine on stuff like that. I don't know it. I don't want to say that about anybody if I'm not sure. And I didn't read any like official documentation of it. The defense playing the TV, smashing the video fell flat, in my opinion. Well, we're going to find out if the chat agrees. The still pics left a different impression. The video made it seem more like drunk fun. Well, Chris K. I was going to say you jumped the gun. I was thinking if that's inappropriate language, but I'm not going to say I disagree with you, but we'll see what happens when we actually play it. Why doesn't she have headphones for sidebars? That would be an abnormal occurrence for most state cases in Florida. You could probably request it and, see if you can get a judge to allow it, but it's not every case that happens in, just, where it's just an automatic thing. All right. Is that the end of that clip? Just a little bit more here.
Of the narcissistic personality disorder?
Well, it could be. You wouldn't want just that alone. You'd want to see if that was happening in other settings. Is that happening on the job, with friends, with family members? Is it showing up on psychological testing? But certainly that would be a red flag. You'd go, I want to pay more attention to that. I want to investigate that further.
And is it important when evaluating trauma-based disorders, because they're based on emotional reactions, to do that rule out on alcohol or drug use?
Certainly you'd want to do that. It's not usually disguised as a trauma-based disorder. Alcohol and trauma aren't usually rule outs for each other, but it could exacerbate a condition. It could make you diagnose a trauma condition when it's just an adjustment disorder. I say just, I don't mean to minimize it, but it's not as serious as a trauma-based disorder.
Is it important to consider whether the abuser and or the abused behave differently in the absence of alcohol or drugs?
Yes.
And why is that?
Well, because you're trying to analyze a psychological condition. If as a result of drug or alcohol abuse, their behavior changes or their perceptions change, that's not a psychological condition, that's a substance abuse disorder. So that.
And there is a big difference. And obviously that's important to discuss in this case. They discussed the cycle of violence, the honeymoon phase, things like that, how the language has changed from battered woman to battered spouse to battered person. Again, because the state wants to talk about how George is actually the battered spouse from their angle. Jay says it doesn't have to be physical abuse, right? It can be emotional. It can be the partner being mean. And again, he uses a bunch of examples that actually do apply to this case, unlike a lot of the examples the expert used on direct that really don't apply to this case. Isolating from families, keeping identification papers, giving a gift but saying it's still yours. I mean, how gross is that? Somebody else mentioned it earlier. What was the other one? Oh, threatening legal action against somebody. And he's like, yep. That can all be taken as battered spouse. And again, painting a very clear picture. And he does the same exact thing with the other expert to really paint the picture that the abuser is Sarah Boone and the battered person or battered spouse is George. That's the picture the state is painting with these experts. And I think they did a really good job of it. I think the defense did a good job on direct, and I think the state did a good job on cross with both of these experts. We're just going to listen to the last couple minutes here of cross.
Anxiety, low self-esteem, and depression can all be components of battered spouse syndrome, correct?
Correct.
Is it important as the evaluator to rule out whether or not these conditions predated the violent or abusive relationship?
Yes.
And why is that?
Well, because where things start is important diagnostically. So if all of those things were in place, all of the symptoms that were just mentioned are in place, then you wouldn't attribute those to the abuse. You'd say those things were pre-existing. Now, abuse could make it worse, but in terms of your diagnosis, you need to know where things started. So if those symptoms didn't start at the time where there was abuse that was alleged to have occurred, then it's unlikely that it's attributed to that abuse.
And independent of any narcissistic personality disorder traits, would you agree that anybody in a certain legal setting has a motivation to present themselves in a certain way?
Yes, to do impression management, either depending on the outcome. So if there's punitive sanctions, they may lie to make themselves look worse, or as a result, if they're in other settings like divorce settings, they may lie to make themselves look better. So there's always some impression management you have to kind of look through in your evaluation.
And that's important for an evaluator?
It should be looked at in every evaluation.
Thank you.
Interesting as well as it applies to this case and some things that have been said. So energy, I agree. It's very difficult. It's very difficult. The mental health just generally in our country, people, including myself, don't understand it as well as we should, and as well as people that have gone through it and managing it and balancing it and seeing how it all plays into different things in life can be very, very difficult. Jack's snack pack, similar type of comment. I agree. I mean, I think it's hard for me to put myself in her shoes and in his shoes. And what would I be afraid of and what would I do? Now, I am pretty confident I would not have done this, but, you know, the alcohol plays into it, obviously. But calling 911, calling Brian, you know, unzipping it and running, going and getting a neighbor, whatever it may be, a lot of other options, I think, besides what she did. Christy, Doc said Sarah Boone said she thought Torres could unzip it easily after 2 minutes because it was easy for Sarah Boone to unzip it, but she didn't unzip it till the next day. Yeah, I mean, there are holes. There are holes in all of the stories. Allie B, do we have any other read on the jury besides Juror 13, who's a DV victim? Peter, have you or anyone in the chat gotten more feedback or reaction to the jury? Is it possible it could be hung? Everybody thinks it's going to be hung every time. I would not expect it to be hung. A small percentage of cases are hung. I don't have any more of a read on the jury. I was hoping to go see it for myself. Fortunately, it looks like the case is going to end. Fortunately for everybody else, I guess, it looks like the case is going to end by the end of the day Friday. So my plan for coming Monday is falling short. We'll have to figure out how to make up for it. I saw Ashley post earlier. I will make it up to you guys. I promise we'll figure something out. Whitney leaving this week made it impossible. I'm on daddy duty. And of course, work and everything else. But we'll plan in advance and we'll make something happen. On redirect, he says it's important to put everything together. They confirmed she was not a narcissist. She just had some of those tendencies. If nothing works, you appease them. Again, that was important because we've heard a lot of Sarah was just appeasing him, or you get depressed. And then after this witness, the defense is like, hey, we're going to let a bunch of our lay witnesses go because of Koepsell's testimony, which made me think maybe they didn't think Koepsell's testimony was going to go as smoothly as it did because she basically agreed. Yeah, no, that guy never told me those specific things. Boone did not necessarily agree with getting rid of some of those lay witnesses. The judge had a colloquy with her and she's like, yes, I agree with my lawyers. Yes, I trust them. Yes, I trust their strategy. Then we get the digital forensic examiner comes back up, and this is when we see the videos of George Torres on Sarah Boone's phone with the bat hitting the TV. So if you remember, he was scarily pointing the bat at the camera, and then we saw the pictures of the destroyed TV. It was pretty scary. And I'll just let the cat out of the bag. I kind of agree with Chris. Those pictures seem scarier than this video did. I don't know why. If you guys can tell me why, let me know and see. Let me know if you agree or disagree in the chat.
You're going to help me take it out. You're going to help me take this shit out. Real shit. You're going to help me take it out. You're going to help me take this shit out. That's bad as I want to.
So those were the two videos that they played from Sarah's phone. Take from it what you may. Then Ms. Walker testifies, lives by Sarah Boone for 4 years. She was basically a character witness to talk about how nice Sarah Boone was, never looked down on her, wasn't condescending. She noticed she had, bruisings like somebody hurt her arm and choked her, or injuries around her neck. Sarah was very nice. She could tell that she was scared. They couldn't get into obviously what Sarah said, but when law enforcement would come to the complex, this witness would not get involved. On cross, I did think that Mr. J, and again, he seems to be better with the experts and some of the lay witnesses. He said something like, "You don't have any idea how she got those marks." And the witness is like, "Well, I have some idea. I could hear the dogs barking and them fighting over there." And he's like, "Whoa, whoa, whoa, whoa. What I meant to say was, you didn't see how she got those injuries, right? You don't want to ask questions like, you have no idea. There's no way you could even possibly know." She's like, "Actually, yeah, with some context clues, I could figure out how she got these injuries." Not a good question, but he circled it back around and ended up tightening it up quick. Then we get to Dr. Harper, who was the main battered spouse expert, clinical psychologist. They go through education, experience, background. She talks about how she gets background history, administers tests, reviews prior records, interrogation video, et cetera, et cetera. And they go into some narcissistic traits with her as well, which again, I was like, I don't know if I'd do this if I was the defense, but they did. So we're going to listen to them discuss it.
Her relationship with her mother as part of her psychological development.
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
It's like, we got to make sure you don't think she's a narcissist, but she does have those traits, and let's talk about which ones she has. I was like, I don't see the need to do this because the state's going to do it on cross. Why do it twice, especially so early in the direct?
Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
Woof. Imagine sitting there while somebody's talking about you like that. Eesh. I mean, how do you think Sarah Boone felt while they were talking about her like this? Low self-esteem. She kept exaggerating her good grades. Eesh.
Now, I know there's been reference in this case to a manual that all psychologists...
I'm going to jump ahead a little bit to when she actually talks about what she diagnosed her with. With all experts, there's a lot of background, a lot of, how smart you are, what you use, what the book's called, why, what do you do? But we want to get down to the nitty gritty, which is, what did you diagnose her with and why?
Her mental health records, diagnoses previous clinicians may have arrived at the time when I diagnosed her myself.
Okay, given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose?
By the way, she met with Sarah 9 times, and that's important in the defense. I mean, the state, I think, felt some type of way about it because right when they start, they're like, you met with her 9 times, but we're only allowed to meet with her once. And we'll talk about that argument, what they were getting at when we get there. But 9 times is a lot to meet with somebody. And again, that adds to the credibility of these witnesses.
Sarah Boone with anything?
Yes, so post-traumatic stress disorder, it's my opinion at the time of the offense, she had depression and she had an alcohol use disorder.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands.
She mentioned like anxiety before as well, but PTSD, alcoholism, depression were the main 3.
Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely...
Sustain.
So she can't repeat what Sarah Boone says, but you can say stuff like, I have all these records and pictures, medical records, police reports that I reviewed, and there were events that I saw that happened in her life that were the main triggers for the PTSD, such as getting stabbed in the leg. It's the way you have to testify. You can't say Sarah Boone said this. You can rely on hearsay, of course. You can rely on hearsay, of course, as an expert. B, Scott Boo, Barry Adams, a bunch of you guys throwing in. Yeah, I think you're right. Like, she seemed to be in on something they were doing together. They repositioned the TV, things like that definitely made it feel different than the pictures felt.
You have viewed have you viewed some exhibits involving her being stabbed?
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Right, you're saying?
Overruled.
Just generally, without getting specific, I think I've explained post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping. So their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all
They
features.
have trouble sleeping sometimes.
Yes.
Sleep deprivation is a real issue.
It's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And this is a lot of background. And then they're going to get into exactly what caused the PTSD and the battered spouse and whether or not it applies to Sarah Boone. They're going to get into this as kind of some of the background. A lot of you guys, including Crazy Cat Queen, are putting my thoughts and feelings into words perfectly. I felt kind of the same way, that it was already broken. You're going to help me take it out. They were kind of joking about it. He hits it. They move it around so it's a good view for the camera, because how often do you get to take a bat to a TV? That's pretty cool, I guess. I agree with a lot of these comments.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
Or can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right? And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
And alcoholism.
And everybody basically agrees that that's something that happened in this case. So Daybreak, yeah, depending on the facts and the circumstances, it could be manslaughter, it could be murder too. The jury has to differentiate between the verbiage, if the lesser includeds are going to be included in this case, and see which one it fits more into. I have always felt like this was a manslaughter case. That's what I've always felt. Could be wrong. It's weird that now she's kind of saying she intentionally left him in there. Makes me think I was wrong even by her definition. But if we gave her truth serum, I do believe some of this was at least accidental or done because of alcohol, which is not a crime, but I think it fits more into manslaughter second degree. And I know a lot of people disagree with me in the chat. A lot of people agree with me, but that's fine. Rebecca said, Sarah definitely has a personality disorder. Add alcohol, nothing good happens. Being drunk does not excuse her. Substance abuse cannot be used as an excuse for everything. I see this way too often. Yeah. And that's why a lot of states do not have voluntary intoxication as an actual defense. Katie, hi, Peter. Notice the judge keeps asking Sarah Boone if she's still happy with her attorneys. Is that normal? Never seen it before in the many Florida trials we've watched. So I have seen it before. I have had it happen before. I think judges do it for some defendants, some specific defendants, maybe some difficult defendants. Obviously, Sarah Boone has a history of disagreeing with her lawyers and firing her lawyers. So I think he's protecting the record for appeal, trying to keep this thing going smoothly. And she seems to like what her lawyers are doing. So why not get it on the record? It's not perfect, but I think it's a really smart thing for the judge to do. Is it common for there to be this many approach the bench conversations? So I would say yes, Marissa. This is how a trial should go. It doesn't, to me, seem like outlandish how many times they're approaching the bench. It's objection, legal reasoning, no speaking objections. If we're going to argue about it, if we're going to speak about the objection, you need to come up to the bench and we'll discuss it here. quietly. And then I'll make a decision and everybody goes back and we carry on. That's how it should be. It shouldn't be, objection, judge. That's not even true. That's not how Sarah Boone testified. Because now you're making an argument in front of the jury to try to sway the jury and how they're thinking. So this is how I like it to go. I think it's simple. I think they go up, they go back. The judge doesn't take forever to make decisions. So I haven't noticed it be clunky, but maybe I'm wrong. Hi, Peter. Where are Sarah's witnesses to show she was a victim of DV? She has a few experts and that's it. Why aren't Lucas and Brian Boone testifying for her? Where are family and friends? Well, folks, I think this is going to come up later. The state asks this witness, why you didn't talk to Brian Boone? Why didn't you talk to Lucas? And I think Brian Boone's going to testify in rebuttal. So I think the state's hoping the jury is asking the same exact question, Daisy. Who needs the state when you have a defense like this? Okay. They're trying to get ahead of the state with narcissism. Yeah, I mean, I don't know. Just to me, it sounded like the jury just got to hear it twice. Does it matter whether you bring a clinician versus a forensic psychologist as an expert? Would think lawyers would prefer forensic psychologists, right? So that's funny, Joe. And this is a question I'll chat for the chat. I'll try not to take too much time with my side story, but I prefer to just have, like for my clients, they're treating doctors. Who did you go to? Who sent you to get MRIs? Who did your surgery? Who did the injections? Because they're going to come testify because they're just practicing doctors, right? They're there to help you and all their other patients that come in the door, as opposed to a hired gun who looks over records, testifies. They're an expert at testifying. They're forensic, right? And psychology is a little bit different than spine and other things, but I like the people that majority of their practice is treating other people. Other lawyers might not, because some of the professional experts are just better at testifying. I always think it's up to the jury. What does a jury prefer? So what I prefer may be different than what you prefer as a potential juror. So you guys let me know. Do you think it's better to have the person that's actually treating these people, helping these people come and just testify to why they did what they did? Or somebody who has maybe a better presentation, can explain all the rules, knows the legalities, can fit all the pieces together, and has reviewed every single stitch of paper in this case? And usually what we'll do is we'll have a combination of both. That's usually what I do, just to try to catch all the jurors that want one or the other. We don't leave that up to chance. Okay. Let's get into some more of her battered spouse discussion.
Yes.
Critical context.
Yes, I understand that.
Can you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
That's the subjective element, is like what they've been through creates this fear, but a reasonable person still has to have been afraid if they had the same experiences as Sarah Boone. So it's kind of, there's subjective and objective analysis that has to be done.
I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Her research study generated the term. She was interested in why battered women specifically, at first, that was what was studied, didn't leave their partner because, of course, they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
And just briefly touch on, because I know Dr. Brannon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event. So something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's like called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically, the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim that's getting abused, and you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone or some small behavior that might not mean much to another person, but it has preceded other violent acts. So for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home. And that could be a signal like abuse and violence has occurred.
And that is kind of what she said. I knew where it was going based on his action. I knew this was that. That's why I placated him. So a lot of what this expert was applying it to Sarah Boone specifically, was applying it to the facts of this case. And again, I always say this as a trial lawyer, if you start to get jurors on your side, they're going to pick up what you put down, right? They're going to believe you. They're going to be with you. If they're not, they're going to be like, oh, she's biased, blah, blah, blah. Reese's mom's like, she seemed totally biased. Is that expected from a defense witness? So, I mean, I kind of expect it from every witness. If you're testifying for a side, some people call it bias. I say, if a side is calling you, probably what you have to say is good for them. So I don't call you biased for that, but I expect you to be good for them. But I do think, I'm not going to call you out, Reese's mom, but if you're kind of thinking Sarah Boone's guilty of at least something, then it may not be weird for you to think the witnesses that are good for her, or a witness like this, is biased, right? And lots of times at this point in the trial, jurors are starting to feel that way. This made me laugh, Amelia. Innocence cloak looking a little dusty. That I literally laughed when I read it in the chat. And again, cloaked in the presumption of innocence at the beginning of the trial. During the state's case in chief, they start putting the puzzle together, building the house, whatever you want to say, proving this case beyond a reasonable doubt. So it's very reasonable at this point if jurors are starting to think Sarah Boone might be guilty. They got a reserve ruling till the end of the case, but the state's built their case. They rested their case in chief. They still have rebuttal, but it's kind of a good analogy. The innocence cloak getting a little dusty here, I think. Phyllis, hey, Peter, can you take a poll? Please, appreciate you. So Phyllis, I never take a poll. At least I try not to. Maybe I have in the past, but I try not to take a poll until all the evidence is done. So tomorrow, I think we're going to be completely done with the defense's case and the rebuttal case. So tomorrow night's video, John, Chelsey, remind me, or Phyllis, remind me, we will do polls, guilty, not guilty, manslaughter, second degree, voluntary manslaughter, involuntary. We'll do a bunch of different polls as far as where people sit at that point if you were on this jury. Do you think the prosecution will bring up her violence towards him? Absolutely. It's easy to make accusations on the other person isn't there to defend themselves. Yes. He even asked this witness, the prosecutor's like, you didn't interview George Torres, did you? And she's like, obviously, no, I did not. That's important though. I think that's a good question. Tater Tot, do lawyers have to go to experts they use often? Do you mean go to them like to treat with them as doctors? No. But like talk to them? Yeah. I mean, you build a rapport, you learn. I learn a lot from the experts. I'm like, explain battered spouse syndrome to me, explain narcissistic personality disorder, explain all this to me. I want to understand it so I understand how to ask you questions appropriately. So we learn a lot from our experts. Do you think manslaughter for someone who killed someone drunk driving is strong enough charge? I don't. What's the difference? My Nana was killed by a drunk driver, Pantufel. I'm so sorry to hear that. I work on a lot of these exact kind of cases on the victim side, on the personal injury side. I mean, it's hard. It's hard, right? Because they intentionally got drunk and intentionally got behind the wheel of a car. So vehicular homicide, vehicular manslaughter. I get it why we think it should be more. There are some places where there are enhancements and penalties that are even worse. I probably would be up for that. I mean, it's brutal. There's no other way to say it, but it's brutal. I think it's a personal choice who you call. It has made you the attorney that you are today, Peter. Thank you. But I love getting the input from you guys and potential jurors because you guys are the types of decision makers in these cases. What will be the jury instruction? Surely it can't be, did she do this? Well, we're going to hear the jury instructions either tomorrow or Friday, and we'll go through that one specifically together. Peter, how do you know if any of the jurors are honest about knowing about the case when selected to be on the jury? I mean, anyone can lie, right? So mixed moods with Mojo. This is a trial lawyer's greatest fear, that the jurors are just lying to you. They want to get on for one reason or another, and it can be really tough, but you got to have some trust. You got to have some faith in the system and hope that it works out. and hope that if they do say something or give off anything of it, other jurors will call them out. Somebody will hear something and you'll find out about it. But it's tough. There's no other way around it. It's tough. Joe said, I prefer forensic. Clinical psychologist understandably focuses on treatment and patient advocacy, so I might question patient-leaning bias and objectivity. I get it, but I mean, if all you do is testify for who pays you, I think I can make an argument that, that creates a bit of bias too. Brittany said, I was 100% guilty, but after DV testimony, I'm not guilty. And this is the point. Like, people don't think this defense can work. It absolutely can work and has worked in the past. I don't know. I found this witness's cross disgusting. Like that Smeagol guy from Depp, every answer was pulling teeth. Oh, okay. You meant she was disgusting. I thought you were going to say Mr. J was disgusting to her. I said, I thought it was a pretty good cross. All right, let's get back to her direct.
In his stay-at-home clothes, for instance, that might not mean much to another person because, again, it's specific to that dyad. Those two people know those patterns. So the victim may perceive a small or subtle change in their partner cue because they've become hypervigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you diagnosed Sarah Boone with. When those personality changes occur, and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of, scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
So that's the gist. That's the defense in a gist. I'll back it up so we can listen to it one more time. Her answer right here is the battered spouse defense in a gist. That's why they were allowed to get here, because there was a scintilla of evidence to get us here. This is what the jury is going to have to consider as the self-defense. We'll listen to it one more time.
She was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
Then it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur.
Yes.
When a threat was about to occur.
Yes.
Threat of danger.
That's right.
Now I want to talk about placating the abuser, a victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal, in which the battered woman may attempt to reduce through several different means to delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. It doesn't always stop it.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Again, I don't understand this question. Are her words her power? When the state, you know how the state's going to cross this witness. The state already crossed the last witness on this exact subject about how verbal abuse can be the weapon of choice for a battering spouse.
Her words, I would say, are the weapon that she has.
Here we go again. Right at like the one, right when we pass 1 hour. It's like YouTube telling me to keep these videos to an hour. I swear. It's like YouTube telling me to keep these videos to an hour. Let's see what else. They go through what could be included as bad acts. He uses, a bunch of examples that we heard come in through testimony that she suffered from severe psychological distress. They go through all the photos of the domestic violence. And then he kind of ends with, you saw Sarah Boone 9 times. Was that enough? So we'll listen to that, and then we'll kind of hear exactly how the state starts out their cross.
Discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times they're very slow to open up and tell you about the abuse.
That is correct.
They'll actually often lie about it.
Deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's a result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and give to the school?
Yes.
That's all the questions I have.
And that and the state starts out with, well, we're only allowed to talk to her once. Isn't that right? You've done court-appointed work, and the judge only allows us to do it once, and there's an objection. What he's trying to say is it's kind of asking her to give a legal conclusion. And she doesn't know like what a court's going to order. She's not a lawyer. He is correct. A compulsory medical exam that the state's allowed to do is just 1 appointment. So comparing 1 to 9 maybe isn't fair, but that's what the defense is absolutely trying to do. All right, let me answer some questions before we get to cross. Just kidding, of course, but it does feel like a lot of the defense tactics are implicating more than absolving her, depending on how you see the situation. Thoughts? I do think they've asked some questions that I don't feel like are necessary, and I think some of them could end up smacking him back in the face, depending on how a jury looks at it. Azam, do you think the jury will start to deliberate next week? Unfortunately, I think they're going to start deliberating Friday, and they might be done by Friday. If they are deliberating Monday, I will still go down there for jury watch, and maybe I'll be there for the verdict. We'll see. Can the prosecution recall anyone to restate Sarah's injuries to George? What about her DV arrest? Did that come in, even his family? So yeah, I think they're going to play a lot of the body cam footage, and we're going to get to hear exactly what was going on there. I don't know who all there. I think Brian Boone's going to talk about how Sarah Boone, they abused each other, and how, or not Sarah Boone and Brian, but George and Sarah Boone, and then how Sarah Boone would hit Brian. We know he already said that in the body cam footage in the interview. So I think they are going to have stuff like that. How can jurors get the image of Sarah shaking the suitcase and yelling, "Why are you doing this to me?" Also very funny, when she tries to sound smart, she speaks Latin, compos mentis, factus, etc. Manly, this exact point is why one of the last things I would do in rebuttal as the state is play that video again. As an ER nurse and an ophthalmologist, in live chat today, say the black eye was off, no swelling or eye involvement, black circle didn't look normal. Thoughts? Well, I got to be honest with you, looked like a black eye to me. As a lawyer and not a nurse or an ophthalmologist, I would take your opinion over mine for sure. Can the state recall Sarah Boone? So I did a long thing on this in the beginning. I don't think practically it's ever going to happen, but theoretically, I think there's an argument to be made that once an accused waives their right, they can be treated as any other witness, and any other witness can be called in rebuttal, as long as they have rebuttal testimony, not just to call them again, not just to hurt them, things like that. Could the state ask a person if a person read books about the syndrome and tailor their response based on what they've read? Think primal fear? Yes, they could have asked Sarah Boone that. Obviously, any expert's going to have read all the books on this stuff. All right, let's get to a chunk of her cross here. He asked a lot of the same questions as Brannon, but let's hear him talk about some of the stuff Sarah Boone did to George.
So you would agree that, hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Propping one up, hypothetically saying, "I'm the best thing that has ever happened to you. You'll never do better than me." Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of potential exertion of control over an intimate partner when you give somebody hypothetically a bike, but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Now I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit. Okay.
I hate when lawyers do that, but when it works, it's worth it. And it worked for him because she did start limiting it. Now, if I was Mr. Owens, I would say, Judge, she can say yes or no, and she can explain her answer if she needs to explain it. He can't cut her off from explaining her answer. She does need to start with yes or no. I've seen that. I would battle with that because I would hate it for him to make my expert only say yes or no. Joe said, based on my simpleton read of Florida Statute 7820423, I could see a good fit for second degree. It's not premeditated. State could prove the act was imminently dangerous to George and it evinces a depraved mind. The video of Sarah mocking him. Listen, I'm not saying it's an impossible case for second degree. I'm not saying that. I can understand how a jury might get second degree. Me personally, the way I read all the statutes, and we'll go through the differences. I hope they do the lesser included. If they don't, we will look at the manslaughter statute here. I have just always felt like it fit more into that myself. But again, I was going off it's not intentional, it was an accident, et cetera, et cetera. That's not the story anymore, I guess. Right. And even with this witness, he's like, didn't she swear on her son's life that this was unintentional? And the expert's like, yeah, she did. I also don't know. Like, is the jury picking up on this nuance? Like, unintentional is the opposite of what she's saying now. Are they picking up on that? Like, for us who've been digging into this for literally years, I don't know if they are.
Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've described.
So I will just somewhat agree with. I don't fully agree with this comment, but I will say I do think the defense attorneys seem like they have nice personalities. The prosecutors seem more dry and sticking to the point, and we're here to do our job. And the defense attorneys have more personality. I do agree with that part of it. I don't think he's always aggressive and snide. I think he does do that sometimes. And I do think Owens can be charming. I can understand some people think that's annoying. You always have to, kind of worry about that as a trial lawyer. I'm not saying I do, right? They all seem like very nice gentlemen and like they're doing a good job. But yeah, I can get where you're picking that up. And again, that's another thing that a lot of jurors I've interviewed have told me. They absolutely pick up on that type of personality traits from the different lawyers.
The tension building, the blow up, and then the honeymoon phase. You would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And
all right, so here we go. This is a first date. I don't even know what this makes me think. Like when I first listened to it, by the way, this witness also said, oh, are you talking about the 2 times she was Baker acted? I was like, what? That's coming out? Like, I don't think that would have been admissible. The prosecutor did not dive into it. The expert absolutely said it. I didn't know she had been Baker acted twice. Now the jury knows she's been Baker acted twice. I will also tell you, jurors notice that in Florida, we know what Baker acting means. And that's usually not a good thing either. That's what I was talking about. You talk about shared custody. It's like, oh, okay, she got shared custody of her son, so she's not that bad. Baker acted twice. Personality disorder, narcissistic personality disorder. They start to paint this picture of Sarah Boone that's not as victim sympathetic. And by the way, Baker Act, a lot of people can't control it. A lot of times it's really sad. A lot of times it has to do with substance abuse and other different reasons, but it has a negative connotation two jurors that don't know you, two people that don't know you. And that's usually why it doesn't come in, is because it's irrelevant and could be prejudicial against the defendant. That is the argument lawyers say. Oh, people don't know what Baker Act is. A Baker Act is, 48-hour hold, can be longer than that because you're a danger to yourself or somebody else. It can be substance abuse. It can be all sorts of different things, but it usually has a connotation that is negative, which is why it's usually not coming in. And those are the reasons the lawyers argue to not allow it to come in.
The time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her,
Correct.
and she described that she was all bruised up, correct?
Yes.
After that,
I mean, that's wild. That was the first date. People are still asking what Baker Act was. So basically you're a danger to yourself or to someone else and they can hold you for 72 hours. When I was at the state attorney's office, I did a couple Baker Act hearings. Whoa, those things are wild. Like those things are wild. I feel so bad for 95% of the people in there, 5% of the people in there. I'm a little scared of. I had a guy like stand on a chair in the corner throughout the entire thing. It was so sad. And there's a doctor in there trying to help him. And I'm a 20, well, how old would I have been? 25-year-old lawyer. And I'm like, I've got like my list of questions that somebody gave me to ask. It was quite a learning experience, But yeah, it's not a good thing. It's a really sad thing and a sad situation for people that end up there.
this is the first time she had ever met him, correct?
I believe so.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different, hypothetically, than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids.
She's saying it's not really the same thing, or he's saying it's not really the same thing. And Sarah Boone's kind of embellishing or, hyperbolic about some of this. He goes into some of the records that this expert did not review. I'm going to leave this comment up for a second from Chris. They talk about how alcohol can affect credibility. And she said, well, only if they're intoxicated at the time they're actually talking to me. He gets into some of the records where she complains about X, Y, or Z with depression, but not intimate partner violence, more like her husband and her son are leaving. She feels lonely. And then, as one of our last clips of the night, we're going to get into Mr. J going hard at the narcissistic personality disorder.
Your hard copy?
Thank you. All right.
I have a digital copy.
760, but
Yeah. Andy, I feel that way about a lot of things, that so much speculation and all this stuff. Like, why didn't they do this? Why didn't they do that? If they had evidence of it, I think they would have gone into it more. That's not to say that it's impossible. And they may think the same thing. They may think it was fake too, but if they can't prove it, then you're not going to be able to argue it to a jury.
One of the criteria is has a grandiose sense of self-importance. For example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high-status people, friends, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criteria.
4, requires excessive admiration.
Yes.
5, has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6, is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative. I agree.
7, lacks empathy, is unwilling to recognize or identify with the feelings and needs of others. Correct?
Yes.
8, is often envious of others or believes that others are envious of him or her. Correct?
Yes.
9, shows arrogant or haughty behaviors or attitudes.
Yes.
Now, you believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of self-importance.
He's like, you think she hits some of those? Let's go through them one by one and see which ones she hits.
There are indications that she feels like that or has expressed that before.
So that's a yes.
Yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love.
No.
You remember going to the state attorney's office on October 1st?
Okay, I wanted to pause here for a second. So we talk about impeachment all the time, and these lawyers that fumble through impeachment, and it's like, this was perfect impeachment. He did it quickly. He asked the right questions, the right foundation questions. More importantly, the question he asked first during trial just then was the same exact question he asked at the deposition. That's good preparation. That's clean. That's no objection, judge. You use a different word. None of that. This was such a perfect impeachment process by Mr. J here to impeach this witness.
No.
You remember going to the state attorney's office on October 1st, 2024 and giving a deposition?
I do.
And it was in front of the court reporter, like Madam Court Reporter here.
Yes.
And you swore to tell the truth, the whole truth, nothing but the truth, correct? And referring to page 89, lines 18 through 20. Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
He didn't say, were you lying there or were you lying now? He didn't do any of that. He was just like, without skipping a beat, well, and I guarantee you he's asking these questions and he's either reading from the deposition or he has the cites right next to all of his questions. Very good job. Very prepared job. All right. What else does Sarah Boone have as part of this narcissism?
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement.
Yes.
Is not interpersonally exploitive.
Correct. He is not.
And when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware if she's inconveniencing others.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct? For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right.
So she fits 3, but in order to get the diagnosis, you need 5. So technically she doesn't have narcissistic personality disorder. And here's the point. If that's the only time the jury heard about it, I think it would have been less effective. But because the defense had asked about it and they asked the other witness about it, it's like they've heard about it a lot. Some of them are going to say, in my opinion, sounds like Sarah Boone's really close to being a narcissist, and that's not good either, right? So the state is building up this negativity, but I think the defense has actually done a pretty good job of making her a sympathetic victim who is at least, a battered spouse. Maybe she was also an abuser, mutual abuse, things like that. We're going to wait for rebuttal. But I do think the defense has presented it in about as good of a way as you can. What better could they have done with their facts? That's a question I would have. Now, I don't love the legal arguments. Like I already talked about some of the nuances I would have done different about. I intended to stop him, but then I passed out because I was drunk, whatever it may have been, the partial unintentional element. Lawyer 2 said, I think the defense team has done a great job handling her. Not easy to prepare any client, especially this one, to sit and listen without reaction. All in all, a very interesting case with solid work by all, including the court so far. I tend to agree. Has it been perfect? No. But with 40 days to prepare or whatever, I think they did a pretty good job. On all sides. Let's see what else. They talk more about what she didn't do, who she didn't talk to, that Sarah did not indicate to her that she forgot parts of the night. But the expert said that wouldn't affect her diagnosis. Didn't ask confrontational to her because she was trying to give her space to tell her story. I think that's kind of normal to do for somebody that's been through a lot of trauma. This last little 1 minute clip here of the cross about, that Sarah Boone was, whether or not she was helpful to police.
Reviewed it. I saw the timestamp. Yeah,
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police.
Yes.
Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs?
Yes.
So yeah, I mean, was she helpful to the police? She's like, well, talking to them without counsel present is helpful to the police. It's like, yeah, but lying to them is not helpful. And now she's saying she lied, which is why it's so tough when you admit and say, I lied. It's really tough because that can really be used against you a lot if you're a criminal defendant in a trial. And he talks about how, did you confront her about the damage and bruising done to George, not matching, just poking him with the bat? And you didn't get George's side of the story. On redirect, the defense did a good job again with what they have. Examples of control, that could be threatening animals, taking car keys, destroying things like the TV, not paying bills, violating court orders, et cetera, et cetera. And then one of the things they want to do is get in those court orders and want the judge to take judicial notice. And they struggled so much making the legal argument. Again, these are very experienced criminal defense attorneys. They're probably very tired. They've done a lot of work. We're going to give them a little grace. And they make a business record exception argument to hearsay. It seems like the judge and the prosecutor know the correct argument is it is a public record, the public record exception, because even the prosecutor mentioned something, the judge is like, I'm waiting for that argument, and they were going to bring in the clerk and do all this stuff, and eventually the state's like, whatever, we'll withdraw our objection because everybody kind of knows those things can come in. There's a public records exception, the judge can take judicial notice of it, and that's what's going to happen seemingly tomorrow. Because the defense is going to have, 10, 15 minutes of case of doing that tomorrow before they arrest. Then the state's expert's going to be about an hour, then 2 to 3 hours of videos, text messages, etc. So that's about, let's just say 4 to 4.5 hours. So at least the morning through lunch. And then maybe after lunch, they rest after their rebuttal. Then we have jury instructions. I would expect then closing arguments to be Friday morning, which would then mean that the jury could potentially get the case on Friday and we could potentially have a verdict on Friday. If we don't, like I said, and they decide not to deliberate over the weekend, then I'll drive up there on Monday and be up there, which would be kind of interesting, cool to see who's around the courthouse and stuff while we just wait for a verdict. I did think this was cool too. So before we go, I'm going to play one more last clip where the judge read, because we know all about the Miranda and the card, and did they do anything wrong with Sarah Boone? Did they ask her anything improper? Did they coerce her? Well, there is a special jury instruction about officers asking questions to Sarah Boone that they're going to read to the jury. And let's listen to that one together. They seemingly have agreed on this.
And provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements. The jury is to consider instruction. It's 3.9b. And it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Okay.
let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you, Judge.
Okay. Anything else, State, we need to address?
Thank you, Your Honor.
Defense, anything else? Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence.
And so that was it. And I just thought that was interesting based on some of the other conversations we've had. Jen said, did the judge allow battered spouse in order to avoid an appeal? Potentially, but I also think he just thought it was the right thing based on the scintilla of evidence that was provided. Real quick, did you hear about the motion the state filed about defense conflict of interest because Sarah gave them rights to her story to represent her? So I don't see that detail about her giving them rights. What I see is the state is concerned about a potential conflict of interest between the defendant and her team. Rules regulating the Florida Bar 4-1.8. Only way for the court to know if there is an actual conflict of interest rather than a potential conflict of interest is to review the financial agreements between the defendant and her team. If there is an actual conflict, the defendant can waive the conflict with clear, unequivocal, unambiguous language. For a waiver to be valid, the record must show that the defendant was aware of the conflict of interest and the defendant realized the conflict could affect the defense and the defendant knew of the right to obtain other counsel. The state is requesting the court to conduct an in-camera examination of the financial agreement to assure that there is no actual conflict of interest and that if there is an actual conflict of interest, the defendant validly waives an actual conflict of interest. So they don't really say what it is. They say they're expending a lot of money, resources, and time, and it seems like there might be a conflict of interest here as it goes with payment. I don't know what that means. I don't want to speculate if they're saying that she is paying them, but she's getting indigent status, or if something nefarious is going on. I don't know. I don't want to speculate. If we get more information on it, I'll absolutely discuss it. But at this point, that's all I know. Off topic, will you be summarizing the big mistrial without prejudice explosion today in YSL tomorrow? No, I will not be breaking that down tomorrow. I don't have time, unfortunately. I would love to. I have not had time to follow YSL besides the updates kind of randomly because I'm watching this trial, working at the same time, doing all sorts of other stuff. I'm just crazy busy. It's not possible for me to fully follow that YSL trial at this point because the Sarah Boone trial, the Delphi trial, and everything else that's going on, unfortunately. Peter, at any time in your career thus far, would there have been a time where you would have volunteered to take this case as the ninth? No, tie-by. This would not have been one that I would have taken. Asphalt Sally. Her whole defense is she's scared, not mad. It doesn't matter what he said. Mr. J missed a perfect mic drop moment. Beat Miami. Keep the faith, Peter. Come on, PJ. You know better than that. Sri, makeup alt. Come to the FSU UNC home game. I've already gone to my one FSU game this year. I don't think I'm going back up. I can't handle that. It's bad for my health. Someone's been watching the Adelson's fiasco. Hey, that's a good point. That could be an issue. And Willow, thank you for the super sticker on our way out. You guys are the best. I appreciate you so much. Thank you for coming. Please hit that like button if you haven't already. Please subscribe if you guys haven't already. Thanks for sticking around for some more overtime. Less than an hour and a half, right? Less than an hour and a half this time. So that's good time, right? All right. That's all I got. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.